Hello, my name's Edmund Townsend. I'm the course convener of the insurance law module on the LLM. Insurance is a fascinating subject. In legal terms, it covers contract law, equitable doctrines, and there are various statutes that apply, so there's a real mix of legal doctrines. As a subject, it has enormous practical application because anyone who wishes to work in the field of litigation is going to find that almost invariably at least one of the parties in litigation will have an insurance policy backing them, and so inevitably during the course of litigation collateral issues will arise between the insurer and the litigating party, and so having a grounding in the principles that apply to insurance contracts is of enormous benefit. So anyone who's looking to undertake a training contract in the city should seriously consider looking at an insurance module, or perhaps the marine insurance module. It's a particularly interesting time to study insurance contract law because the Law Commissions of England and Wales and the Law Commission of Scotland have undertaken a joint project looking at insurance contract law, and as a result of that there have been some statutory changes with the Consumer Insurance Disclosure and Representations Act 2012 and the Insurance Act 2015. So the course will cover both the regimes that applied to contracts before those new statutory regimes came into force, but also the regimes that apply now that they are in force. As course convener, I'll teach the majority of the course, but we're also lucky enough to have Professor John Lowry who will join me in teaching some of the classes. There will be 20 lectures in total, spread over 2 terms. The lectures, though, are perhaps more in the style of a seminar because we tend to have a relatively small group, and I do encourage active participation. And so the plan would be that you would have read the base materials before coming to the class, and so if you have any problems as a result of that, we can deal with it in class. The course follows a broadly chronological pattern, so we will start by looking at what insurance is and whether one can define insurance in legal terms. We will then explore some of the principles of the law of agency as it applies to insurance, because most insurance contracts come into being through intermediaries. And then we will look in detail at the principles of good faith. Insurance contracts are different to most other forms of contract in that they are contracts of utmost good faith, and that tends to have an overriding influence across many different subjects in relation to insurance contracts. We will then look at the principles that apply to the formation of insurance contracts and look at the legal doctrines of insurable interest. And then in the second term we will look at terms, the different kinds of terms that are often used in insurance contracts, and then look at how one tends to interpret those terms or to construe those terms. We will look at causation, which is very important in the context of insurance, because when you are looking to bring a claim against an insurance policy, you will need to establish that the loss has been caused by a peril that the insurer agreed to accept. We will then look at the claims process and the sorts of terms that are involved in insurance policies that apply to claims, and what happens where the assured makes a fraudulent claim, and what happens where the insurer perhaps breaches its obligation of utmost good faith in delaying payment of the claim where it ought not to do so. We will then finally look at the principle and doctrine of indemnity and the doctrine of subrogation. So that's what happens once a claim has been paid. Perhaps an insurer may wish to step into the shoes of its insured to bring a claim against a tortfeasor to recover some of its outlay. I hope to see you in September. If you have any queries about the course or you'd like some more information, then feel free to email me.